The chair will begin the questioning process under the 5-minute rule, and I'll recognize myself. Mr. Gupta and Mr. Kramer, could you walk us through how you see the abusive patent litigation environment changing if this bill is enacted? Specifically, how the provisions on fee shifting, heightened pleading standards, discovery, and transparency would reduce litigation, extortion, and abusive practices.
Certainly. Thank you for the opportunity, Chairman.
And you're also going to have to be expeditious about that because I have a few other questions.
I can answer that with one example of a recent case for us. We were sued by a patent assertion entity on a patent that the claims were very vague in terms of the pleadings. There was no specificity as to how we were alleged to infringe, and the product that was identified was a product that we had long discontinued. When we notified the plaintiff about that, we got no response from them for months. About a month before discovery was supposed to close, they served us with requests, and they identified 14 additional products from our company, asking that we produce information and documents related to those 14 products. With about a month left in discovery, we approached the court and said that that was not proper or fair. The court allowed the plaintiff to proceed. We were then asked to produce a significant number of documents to this particular plaintiff. In the meantime, we were seeking some discovery from them, which they vigorously defended and fought. Ultimately, when we got those documents, it turned out that they had licensed a software manufacturer whose software was embedded in our products, and we were all licensed. At that point, they walked away from the suit after having settled in the meantime with tons of companies and having collected settlement fees from them. Now, at the end of the day, we sought to recover our costs and fees from having had to have defended against this frivolous and abusive practice, and our fees were denied. So the provisions in this bill address many of these procedural abuses and would make our lives and the lives of defendants who are faced with these abusive practices a whole lot easier.
So you would say that that company hid the defects in their litigation while they attempted to drive up your litigation costs and procure a settlement, and when that tactic failed because you finally did discover what you needed to discover, you were not awarded any compensation for the added, one would argue, willful contribution to pursuing an abusive and I would say frivolous lawsuit if indeed the products had been properly licensed in the first place. If people had been able to find that out in the first place, you wouldn't have had the problem.
I agree, yes.
Mr. Kramer?
Thank you, Mr. Chairman. The Innovation Act is a bundle of common sense reforms that will help level the playing field, create transparency, and allow defendants to defend themselves in cases. The provision on clarification of Section 285 will provide disincentives for patent trolls to abuse the court system and bring bad cases. The standards with respect to genuine notice pleading in patent cases will encourage the focus of the litigation from the start, so we all know what we're talking about. That will decrease costs for everybody. Staging of discovery until after claim construction will also make litigation more efficient for everyone, both plaintiffs and defendants. Focusing discovery and making presumptive limits on what should be produced will also help everybody by making the process more efficient. Right? So all these things are tremendous steps forward and create a more level playing field for everyone in the litigation.
Thank you. Mr. Kapos, when it comes to the patent system, especially patent ownership, do you believe that it is appropriate for entities to assert a patent far beyond the value of its contribution to the art? Should there be greater requirements to asserting patents in litigation such as fee shifting, heightened pleading standards, and transparency? And can you describe a clearly abusive patent litigation case that you faced in the private sector?
Yeah, well, thanks for the question, Mr. Chairman. I do like in general, the provisions that shift fees, that stay some discovery, that focus discovery. I think that's all good. for the system, whether you're a plaintiff or a defendant, frankly. I think where further consideration is going to be needed is in balancing some of those provisions, for instance, cases where a plaintiff may engage or where a prevailing party may engage in action that's found to be vexatious. So there's fairness on both sides that need to be achieved there. In terms of overbroad claiming, which I think is a great question and central to the issue, I've seen that in any number of situations, both in the government and in my private practice experience. And it is indeed tends to be claims that cover all solutions to a problem, which frequently are business method claims, which brings up the value of the covered business provision as it is currently being worked through the USPTO. And it is those claims that enable, at times, patentees to assert far beyond any contribution they made to the field. And it is those claims, I believe, that this litigation should be directed to in terms of its discovery, fee shifting, and other provisions.
Thank you very much. Chair recognizes the gentleman from Michigan, Mr. Conyers.
Thank you very much, Chairman Goodlatte. I'd like to just follow up with Mr. Kapos on this notion that what we can do to ensure full funding of the USPTO. And I note in your testimony that the GAO found their recent report that patent assertion entities are not driving patent litigation. And I want to find out if you believe that broad new legislation to constrain patent assertion entities is needed in this general range of considerations. What's your view, sir?
Well, thank you, Ranking Member Conyers. And indeed, the GAO report, which was obviously very nonpartisan, found that non-practicing entity behavior is not primarily what's driving litigation. Moreover, there have been scholarly papers that have come out, some within the last few years and even more recently, that are getting the facts and are showing that that when the effects of the AIA are factored out, the total number of lawsuits really is not changing. That being said, I would agree with the assertions of my colleagues here that there clearly is a problem. I don't see the problem as one about identifying bad guys like patent assertion entities or trolls. I see the problem as one of behaviors that anybody can engage in, whether you're a large, well-funded company or a small litigant, whatever sector you're in. And so I applaud the parts of the legislation and the sentiment that I heard earlier to direct our attention toward those actions and behaviors that need to be restrained and redirected rather than trying to label parties.
Thank you very much.
The chair recognizes the gentleman from North Carolina, Mr. Coble, chairman of the subcommittee.
Thank you, Mr. Chairman. Gentlemen, thank you for your testimony. Some of this may become repetitious, but it's nonetheless important. Mr. Gupta, let me ask you this. We've all heard about patent trolls, but what about the patent privateering? That is the situation where a company outsources its patent lawsuits to a shell company to harass competitors. Could such behavior be subject to FTC or DOJ antitrust scrutiny for anti-competitive behavior?
Thank you for the question. I think there is an opportunity for the DOJ and the FTC to investigate and look at those practices, and I understand that they are in the process of doing so. This bill has several provisions that are directed towards the abusive litigation practices that we see today from these PAEs. And while the FTC and the DOJ are looking at those privateering practices, if these provisions are enacted, we should see a significant decrease in abusive practices. And I particularly think that the opportunity to hold PAEs financially accountable for having brought frivolous and abusive litigation would go a long way in changing the basic paradigm, which is that companies, if given an opportunity, or defendants if given an opportunity to defend these actions and not feel extorted to settle in light of the significant expenses associated with getting to judgment, would choose to actually take cases to trial more often than not, and that simply would then break the model of abusive PAEs who thrive on early settlements.
Thank you, sir. Mr. Kramer, how do the Innovation Act's provisions work together to level the playing field in patent litigation? And with that new level playing field, do you expect that we'd see demand letters and suits against small businesses and startups to increase or decrease? And if you would, Mr. Kramer, define demand letter.
Thank you, Congressman, for your question. I'm sorry, I did not catch the last part of that question.
I said, with the proposed new level playing field that we would expect, would we expect the demand letters and suits against small businesses and small startups to increase or decrease?
Thank you, Congressman. I think that the provisions in this bill are common sense reforms that will decrease, decrease those types of demand letters, because once you clarify the standards for fee shifting under Section 285, then all of a sudden there is a disincentive to send out blanket demand letters just willy-nilly and haphazardly, because like the Martha Stewart case that was discussed earlier, that could provoke a declaratory judgment action, and all of a sudden fees could be in play. So I think that the behavior that we're talking about here, abusive patent troll litigation behavior, would actually be disincentivized, and that's for all players in the system, both large and small. The first part of your question with respect to how it would level the playing field, I think it would, the legislation would provide incentives for defendants to actually defend themselves in cases instead of settling more cases and just feeding the behavior. The vicious cycle of troll litigation is such that the more cases there are, the more you settle, the more you pay. The trolls go out and buy more patents to assert against you, and all of a sudden you get more litigation, right? If you stage discovery, if you have presumptive limits on discovery, if you create a disincentive for bringing bad cases in the form of clarifying Section 285, then you will level the playing field. And as a result, you will see fewer bad cases.
And Mr. Kramer, if you would define a demand letter, what is it? What would a demand letter consist of?
Demand letters typically consist of an assertion that your business practices somehow infringe a patent, and they request that you stop doing what you're doing, whatever activity they accuse of infringement.
I thank you, Mr. Chairman. I see that my red light is about to illuminate, so I will yield back.
Chair thanks the gentleman and recognizes the gentleman from North Carolina, Mr. Watt, the ranking member of the subcommittee, for 5 minutes.
Thank you, Mr. Chairman. And let me start by trying to find common ground here. There are some provisions in this bill I think that a number of us agree with. There are other provisions where we have some real concerns. Mr. Capos, there are some provisions that you said you are comfortable with. Can you kind of identify what those are so we can kind of start from common ground? That would be, and maybe you want to just take some time to do that and give that to me following the hearing. The other concern I have is with a case pending on the payment of fees before the Supreme Court now. Mr. Gupta and Mr. Kramer, what would you think the justification would be for this committee acting on that subject before the case is heard and decided by the Supreme Court. Let me go in the reverse order. That's probably an easier, more direct answer to the latter question. Mr. Gupta, Mr. Kramer.
Thank you, Congressman. I think that as the Supreme Court explains or does a better job of qualifying what an exceptional case is, that there is an opportunity here and a much needed change in the law that in the event that we have a plaintiff that brings an abusive action and defendants are forced to spend millions to defend themselves, that there be an opportunity to hold those plaintiffs financially accountable so that there is a shifting of that burden that was entirely felt.
And would you think it would be appropriate to apply that same standard to a defendant who counterclaimed, or would you put him in a different category?
I would completely support a bilateral proposal along those lines where it would be, if it's good for the plaintiff, it's good for the defendant.
And is it your sense that the Supreme Court or the courts don't have that discretion now?
Right now, the default is that there is no shifting of fees. One has to make a showing of exceptional case. This bill, we think, very effectively and will, efficiently address this problem of abusive litigation by making the default be that in the event a defendant is able to show that a plaintiff's claims were objectively baseless, the default would be that there would be a shifting of fees so that there is some financial accountability felt by the non-practicing entity or the PAE who currently has absolutely
This is not restricted to non-practicing entities, is it?
It could be.
I mean, this is everybody in the litigation chain gets this provision gets applied to, does it not?
It does, and I think from our experience, when practicing entities are in litigation, they tend to be a lot more cautious and judicious and thoughtful about claims they bring in litigation because they know that when they assert a claim that they're likely to get a counterclaim. As we've seen with our experience with patent assertion entities, they are not fearful for any of those checks and balances.
Mr. Kramer.
Thank you, Congressman. In short, Congress is in the best position to remedy the situation and address the problem with respect to everyone involved, right? Not just Octane Fitness, which is the case pending before the Supreme Court. And like Mr. Gupta has alluded to, the current bill, the Innovation Act, goes a little bit farther than what the Supreme Court could possibly do in that case, and therefore would provide broader remedy.
You think 535 members of the House and the Senate in a better position to address this question than some thoughtful response from the court? That's what you're saying.
Congressman, thank you for that.
Yeah, okay. I'm just saying, I got you.
The answer is yes.
Okay, all right.
The answer is yes.
You got a lot more confidence in us than I think the public has in us. Mr. Kappas, I gave you a little opportunity. Can you tick off just the provisions that you think are non-controversial in this bill? I guess that's kind of the bottom line of the.
Well, yes. Thank you, Ranking Member Watt. I would start by saying, for instance, the fee shifting provision, which others have lauded here, while not without its issues, including that the Supreme Court is looking at 2 cases right now that involve that, is good policy. But apropos your question, there should be bonding in both directions, that inappropriate behavior on the part of either prevailing party should be kept in mind in applying fee shifting. I think real party and interest is in the category of being fairly non-controversial, although I've heard calls that maybe real party and interest identification should be a little more aggressive than it is, and that more should be required than is currently in the bill. Litigation procedure. We've talked about that. I think that is positive. Stage discovery will cut a lot of unnecessary litigation expense. But once again, there needs to be some reciprocity or bilateralism brought into that. So in the case of a counterclaim party, so an original defendant that makes a counterclaim of invalidity or non-infringement, or a declaratory judgment plaintiff, should have the same requirements as the original patentee relative to stage discovery and paying for the other party's discovery beyond basic limits. But I think the idea is a good one, again, also subject to letting the federal courts do their job and Congress not being overly prescriptive, permitting judges to use judgment. The joinder provision, we've talked about that, clearly positive also in holding to account those parties, like Mr. Kramer pointed out, who are behind the scenes, who are not disclosing their identities. So there's goodness there, but again, some confusion and some lack of clarity in my reading of that provision that can stand more discussion, so that it doesn't wind up being interpreted in a way that a licensee of a patent portfolio becomes subject to joinder, which is, as I read that provision, a risk right now. And then lastly, I would mention stays. We haven't talked very much about that, but that's, I think, a positive provision also. It can protect the innocents, the retailers, and the end users who are brought in sometimes as hostages in patent infringement suits. And I think the provision is good from that respect, but the danger in it, several dangers. One that's prominent is that the way it's written, it can apply to any party in the distribution channel. So from the top of the food chain, if you will, the party that makes the subcomponent then sells it to an aggregator that puts that subcomponent with other subcomponents, creates a card or a board, if I can refer to computers for a moment, then sells that accumulation to another party that assembles the product. I don't think you want all of those intermediary parts of the value chain to be able to benefit from stays. You want that end user or that retailer to benefit. And so I think some tuning, some refinement of the statute will solve those problems.
Thank you, Mr. Chairman. I thank you for your indulgence of allowing the response to go over time.
Not at all. It was a learned response. The chair now recognizes the gentleman from Texas, Mr. Smith, for 5 minutes.
Okay. Thank you, Mr. Chairman. And also, I want to thank you again, Mr. Chairman, for making this subject a priority of the Judiciary Committee. I think it will be one of the most important bills that we consider this year. I also want to welcome back Director Kapos to the witness table, I believe, for the first time since he left PTO and entered the private sector, and it's always nice to hear your expert testimony as well. The Innovation Act codifies the first post-grant review decision on covered business method patents. And I have two questions I'd like to direct to Mr. Armitage, Mr. Kapos, and Mr. Kramer. And the first one is this: what should the committee consider or contemplate as it thinks about the amendments to the program for covered business method patents? And my second question is this: are there any negative consequences to expanding the covered business method program? And Mr. Armitage, could we start with you?
In the course of enacting the American Invents Act, probably the most contentious part of that work was figuring out what role the PTO should play with patents that have already issued. I think there was wide support for post-grant review procedures. Post-grant review takes place immediately after the patent issues. It allows every issue that you could raise in a district court to be raised in the Patent and Trademark Office, and indeed protects the public if it's used and used effectively against patents that might be sued 5 years, 10 years down the road. It becomes much more difficult to justify these procedures once the patent is in the marketplace for several years, investments have been made in reliance on the patent, because you simply can't protect the rights of the patent owner in these procedures to the same degree the rights of the patent owner would be protected in district court. With CBM, this was the last exception to the rule that the PTO should get out of the way after the post-grant review period was over and not consider these issues of patentability. So I would urge the committee to respect that compromise, and if there's a provision in the bill that I would hope might come out, it would be everything related to Chapter 18. I didn't hear any witness testify today that Chapter 18 was needed to get the much-needed litigation reforms done.
Okay, thank you, Mr. Armitage. Mr. Kaplos, Director Kaplos.
Yes, thank you, Chairman Smith. So relative to covered business method issues, I'm first and foremost concerned that covered business method not be expanded in a way that it encompasses all software patents. I think that that sends just a really terrible message about the importance of software innovation and puts into scope a huge number of patents that don't belong in Section 18. As Mr. Armitage has alluded, there's plenty of other provisions of the AIA procedures that those patents are appropriately subject to. I would also say that the extension of the CBM provision to become permanent or to be extended for a number of additional years, it's just too early to say whether that makes sense. There was a great compromise and wonderful work done by Congress, this committee, that set that procedure up as a bridge provision with a set number of years. I just don't see any reason to go and return to that at this point. And then lastly, I'd say while it's too early to measure, with only 15 months, only about 13 months under our belt so far, in a procedure that's designed to take at least 15 months to produce decisions, if you look at what we know so far, there's been over 70 of these things that have been instituted, CBM procedures. That's significantly more than we anticipated at the USPTO, so that could be viewed as a good thing. Participants are investing in the process, and that's good. There's been exactly one decision so far in the Versada case. In that case, the USPTO took out an entire patent, despite that it had been found to be valid previously by a district court, getting rid of a multi-hundred-million-dollar judgment. So if you extrapolate that single event out and just guess that there might be 2/3 of patents that go through the CBM procedure in the next year have their claims either significantly or completely invalidated, you could be looking at a far different world than the one that we were living in a year ago, with huge relief for the companies sitting to my right here at this table, with many, many business method patents having been taken out. And it's in that context that I say it feels like we should let the USPTO and its reviewing courts work a little further, because they're actually making progress with this provision.
Thank you, Mr. Kaplos. Mr. Kramer, my time is expired, but do you have anything you'd like to add briefly?
Yes, Congressman, thank you for the opportunity. The one concern that I would say that the committee should keep in mind is providing low-cost alternatives to district court litigation for bad patents, bad quality patents. The PTO has enacted very good rules that backstop the covered business method program, including identifying that patents that have a technical solution to a technical problem should be excluded from that program. So the program, by its own implementation, by its own rules, is very narrow.
Okay, thank you, Mr. Kramer. Thank you, Mr. Chairman.